The convergence of artificial intelligence and intellectual property law has precipitated a systemic crisis. Welcome to the Great Divergence of 2025 to 2026. For the preceding decade, developers relied on a dual-track strategy, aggressive patenting of models and presumptive fair use of vast data sets. But this equilibrium has collapsed. The legal landscape is now defined by a sharp bifurcation between functional patents and proprietary trade secrets. The traditional patent system is failing to accommodate the abstract, probabilistic nature of applied artificial intelligence. This failure is forcing a massive capital flight toward the black box strategy, relying purely on strict trade secret protection. We are witnessing the birth of a new legal metric, the valuation of entropy reduction in neural networks as a proxy for financial damages. Navigating this volatile environment requires a strategic roadmap where the choice between disclosure and secrecy is a survival imperative. In 2025, the struggle to patent AI reached a breaking point, creating a massive reliability gap across the tech industry. The seminal case, Generative Analytics versus Fox Corporation, serves as the definitive bellwether for the strict limitations of AI patentability. The judiciary is increasingly skeptical of claims seeking to monopolize the application of machine learning rather than its underlying architectural advancement. Generative tried to patent a machine learning system that optimized television scheduling using historical viewership and weather data. The Federal Circuit invalidated these patents, cementing the generic automation doctrine. Optimizing schedules is just a human task done faster. Adding standard machine learning tools to a familiar business process does not make an abstract idea suddenly patent eligible. This ruling establishes that application innovation is categorically ineligible, rendering the vast majority of vertical AI unpatentable. Meanwhile, the U.S. Patent Office attempted a policy pivot, pushing for a more permissive interpretation to bolster American competitiveness. This creates a dangerous paper tiger phenomenon. You might get an AI patent, but it faces a high probability of invalidation in federal court. This reliability gap means AI patents hold little deterrent value against sophisticated competitors. They are reduced to mere marketing signals for investors. Furthermore, the non-obviousness requirement presents a massive hurdle as automated tools skyrocket the baseline capabilities of the ordinary engineer. The mere act of training a model is now legally obvious. To get a patent, you must demonstrate a surprising result defying conventional wisdom. In response to this fragility, the industry has executed a massive strategic pivot toward trade secrets. The opacity of deep learning make them naturally suited. Legal scholars now conceptualize trade secret protection not as a binary right, but as a fluctuating Bayesian probability based on security rigor. The Durenleau decision reshaped the landscape of employee mobility, which is absolutely critical for AI labs fighting a brutal talent war. An employee using authorized files for an unauthorized purpose might not be liable if the employer lacked strict, siloed technical access controls. Distinguishing an employee's residual general skill from a proprietary trade secret is notoriously difficult, leading to draconian internal protocols. Today, the definition of an AI trade secret expands far beyond source code to the precise, valuable recipes for creating intelligence. The most critical secret is the data recipe, the specific ratio and curation of high-quality data sets that determines a model's specific flavor. Then come the model weights, matrices of floating-point numbers representing learned knowledge, acting as the absolute crown jewels of the company. Hyperparameters and training methodologies, discovered through highly expensive trial and error runs, are fiercely guarded as competitive advantages. The value of keeping these elements hidden is quantified by information gain, creating a massive economic delta in performance. But this strategy has a fatal existential vulnerability: discovery during copyright litigation. Plaintiffs will demand to see the training data. To defend against copyright claims, a company must paradoxically reveal its most valuable trade secret to the opposing counsel. This tension between data secrecy and copyright legality exploded in 2025, fracturing the legal map across the United States. In Delaware, the Thomson Reuters versus Ross Intelligence ruling delivered a crushing blow to the generative AI fair use defense. Ross used a third party to create bulk memos derived from Westlaw's proprietary system to train a competing legal research AI. The judge explicitly rejected the intermediate copying defense, noting that expressive legal text is entirely different from functional computer code. The court heavily weighed market substitution. The AI was a direct substitute for Westlaw, competing aggressively for the exact same customers. The black box defense completely failed. Converting text into numerical weights did not cleanse the original sin of unauthorized data ingestion. This ruling effectively mandates expensive licensing for any vertical AI product that actively competes with its own data sources. But California offered a counter-narrative. In Bartz versus Anthropic, the judge split the baby regarding the precise act of training. Judge Alsop agreed that training a foundation model on books was spectacularly transformative, just like a human student learning to write. Under this view, the training process is a non-infringing analysis of statistical patterns in language, shielding massive foundation model developers. However, the ruling contained a poison pill regarding shadow libraries. Maintaining a permanent archive of pirated digital goods is not fair use. This created a liability trap. Companies can theoretically train on the data, but they cannot legally possess the data they need to train on. This zero-sum game turned the legal discovery phase into the most critical, highly contested battlefield of AI litigation. Courts rejected the trust us defense, adapting traditional source code review protocols into siloed data rooms to handle petabytes of data. Reviewers enter air-gapped secure environments where they cannot copy the dataset, only take restricted notes strictly vetted by defense counsel. In some cases, a novel compromise uses cryptographic hashes to perfectly verify infringement without ever revealing the full training corpus. By 2026, information gain entered the legal battlefield as a hard mathematical metric to quantify the specific value of infringed data. Plaintiffs use massive ablation studies, demanding defendants retrain models without their specific data to measure the exact drop in performance. If the plaintiff's data provided a unique high-entropy signal that significantly reduced the loss function, the calculated damages are absolutely massive. Defendants counter with the model collapse defense, arguing they must filter for high information gain data to prevent their models from severely degrading. This frames the copyright infringement as a pure technical necessity to stabilize the neural network rather than a malicious creative theft. Meanwhile, global regulators are pushing for a right to unlearn, demanding models forcibly remove the influence of unauthorized data. But deleting a file's influence from a trained neural network is mathematically difficult, as weights are a lossy, deeply diffused compression of the data. Retraining from scratch costs millions of dollars, and experimental machine unlearning algorithms are imperfect and can heavily degrade performance. If a court orders the disgorgement of the fruit of the poisonous tree, does that legally mean executing the entire multi-million-dollar model? Regulatory nets are tightening elsewhere. Agencies are heavily investigating pseudo-mergers where big tech hires core AI teams to bypass antitrust review. Agentic AI introduces new terrifying liabilities. An autonomous agent accidentally pasting code into a public repo creates massive trade secret leakage. The EU AI Act mandates publishing detailed summaries of training content, creating a transatlantic pincer movement with U.S. copyright litigation. 3 potential futures await: Scenario A sees a world of licensed enclaves where only massive conglomerates can afford the immense data toll. Scenario B is a fair use victory, leading to an arms race of data encryption as companies desperately hide their training sources in the dark. Scenario C visualizes a legislative compulsory license, resolving copyright risk, but completely obliterating the competitive value of trade secret data. For legal intelligence officers, the playbook is strictly defined. Abandon the hope of patenting standard applications immediately. Pivot your entire budget to fortify the black box. Implement siloed data rooms long before litigation ever strikes. Bifurcate your strategy. Rely on transformative fair use for foundation models, but strictly licensed data for vertical fine-tuning applications. The era of move fast and break things is dead. The new survival imperative requires you to move strategically and audit absolutely everything. Subscribe for more insights on the laws that shape business. The law doesn't wait.